Greg Woods teaches criminology, criminal justice, and legal studies courses at San Jose State University and other college campuses throughout Northern California. Calculated to address significant issues impacting our nation, Professor Woods wrote the first of its kind training model, Policing in the Current Political and Social Climate, which he regularly presents to members of the San Jose Police Department and other agency personnel. He regularly participates with the Los Angeles County Sheriff Civilian Oversight Commission to build a bridge between the Los Angeles County Sheriff's Department and the communities it serves. Woods conducted training seminars through a foreign language interpreter to top Beijing police officials from the Ministry of Security of the People's Republic of China, emphasizing sources of legal authority, limitations to the use of force, and legal remedies in response to police misconduct. As an internationally respected legal trend and law enforcement expert, Professor Wood's analysis and commentary are regularly featured on television and radio, podcasts, and in print. He received his Doctor of Jurisprudence from San Francisco Law School and lives and works in the Bay Area.
We are experiencing an epidemic of gun violence in this country. Recently, the parents of a student killed in the 2018 massacre at Marjorie Stoneman Douglas High School in Parkland, Florida, the deadliest high school shooting in United States history, set up and tricked a former president of the National Rifle Association, the NRA, into giving a high school graduation speech defending gun rights in front of 3,044 empty chairs. One chair for each student who couldn't graduate because they were killed by gun violence. A political stunt? Perhaps. Yet it effectively illustrates the severity of the problem. It further invites us to examine the legislative solutions we apply to those societal problems that impact us most. We are living through a stress test, exposing flaws inherent to our justice system. We look to the law to fix those flaws. With our time today, we will examine contemporary legal trends in regard to problems related to gun violence and legislative solutions in response to those problems, impacting the rights and remedies of so many. We will illustrate the tension that exists with competing interests to achieve the same results, public safety, yet we do it with diametrically opposed paths, those paths that are illustrated by the sovereigns of our justice system, the federal government, our individual states, and our cities are all taking note and applying their legislative authority in, well, some ways more onerous than others. We will conclude today with some observations with the impact on practitioners, legal trends regarding gun violence and the history of gun violence in the United States as we explore this trajectory of gun legislation, gun control measures, restrictions on the expectations that come with the Second Amendment. Since 1789, over 230 years, factors contributing to gun violence. Well, modernly, we can take a page from those clinicians that might bring our attention to those factors other than rage and anger and retribution, such as mental health, perhaps domestic violence, substance abuse. So many reasons why an individual might take a firearm and do the worst with it. The problem that our law is approaching with the hope that we will solve this problem once and for all. The problem of death and damage from guns, which is increasing at an alarming rate. At most measurements, we have an average of about 40,000 Americans who die every year from gun violence. In the past year, homicides have rose from 6,000 annually to 8,000, while aggravated assaults involving guns have increased by nearly 33,000. As we remember Parkland and Marjorie Stoneman High School in Florida, we have to remind ourselves that that was the deadliest high school shooting with 17 dead, 17 injured, but not the deadliest school shooting. That uncomfortable distinction rests with Virginia Tech in 2007, 33 dead, 17 injured, followed by the Sandy Hook Elementary School, Newtown, Connecticut in 2012, 28 dead, 2 injured. There was the first high-profile such shooting of the modern era in Austin at the University of Texas in 1966 with 18 dead, 31 injured. And we can't forget Columbine High School in Colorado in 1999 with 15 dead, 21 injured. Seemingly occurring with such regularity, we might forget as it becomes a blur, a bad dream we can't seem to awaken from. Mass shootings in more public places, averaging more than one per day, more shootings than days in the calendar year since Columbine. So, what is a mass shooting? As elusive as the definition, we can try to figure out what the FBI concludes to be a mass shooting or a mass killing, where 4 or more are killed, excluding the shooter. Four fatalities by firearm, excluding the offender or the offenders. But we have to remind ourselves that it's not only schools, these public spaces that are being riddled with bullets. We've been going postal since 1986, when a disgruntled postal worker opened fire at the Edmond post office near Oklahoma City. 14 killed, 6 injured. The shooter died by suicide, as is so often the case. And so, how do we hold that shooter criminally responsible, civilly liable for the damage that they inflict? Might we look to other parties to assess liability, to hold criminal responsibility? Those manufacturers of the firearm, those individuals that are responsible for transferring title, selling, trafficking. It is these individuals who are now within the crosshairs of the most recent stream of legislative solutions as we continually collectively scratch our heads and try to make sense of school shootings, workplace shootings increasing, domestic violence increasing. And as we peel away the veneer of the exterior of these lone wolves who oftentimes have the most severe red flags, those warning signs, those types of signs that we might want to be aware of if that individual is contemplating the acquisition of a firearm, or if they have access to such a firearm after exhibiting such warning signs. Might we now have the authority to enter into that person's personal purview and take from that person who is exhibiting the red flags those very firearms that might be used to do the worst? If we consider domestic violence a factor that we might explore in regard to the tension that might exist, not only in how we respond to the problem, be it from the federal government, the state government, or the city, but we might take a look at an analysis of 749 mass shootings over the past 6 years, which found that about 60% were either domestic violence attacks or committed by men with histories of domestic violence. As we consider to profile these high profile shooters, one fact is undeniable, and that is that the majority of them are men. And they're not unique to a particular age group, even though the young men seem to be shooting up the schools while the old men seem to be shooting up their workplaces. Following nearly every high profile shooting, we hear of warning signs exhibited by the shooter. These indications that a weapon might be used to inflict harm to the community and themselves. With 60% of deaths from firearms in the United States, we have to consider suicide, as is so often that grand farewell that might very well be played out in a very public way, as the majority of those deaths from firearms are in fact self-inflicted. Firearms are the means in approximately half of suicides nationwide. On the West Coast, particularly for some reason, perhaps socioeconomic, perhaps a lack of opportunity, perhaps an attempt at power and control over one's powerless situation. Men who own handguns are 8 times more likely to die of gun suicides than men who don't own handguns. And women who own handguns are 35 times more likely than women who don't. David Studdert at Stanford University, who conducted this analysis, concluded that our findings confirm what virtually every study that has investigated this question over the last 30 years has concluded. Ready access to a gun is a major factor for suicide. We can examine the motivations of an individual who might very well have acquired that firearm lawfully, but who subsequently concludes that that tool of destruction must be used for precisely that reason. Perhaps it's an expression of extremism, political or otherwise. Perhaps it's a hate crime. The Pulse nightclub in Orlando, Florida in 2016, 49 killed, 53 injured. The Walmart store in El Paso, Texas in 2019, 22 killed, 24 injured. And 10 people were killed at the King Soopers grocery store in Boulder, Colorado in 2021. Colorado's worst since a gunman killed 12 and injured 70 in an Aurora movie theater in 2012. And we might consider that what happens in Vegas stays in Vegas, yet what happens in Vegas seems to be enveloping our nation in the worst way, because what happened in Vegas was the deadliest mass shooting committed by an individual in modern American history. In 2017, 60 people were killed and 867 injured when more than 1,000 rounds were fired from the high position of the shooter's 32nd floor room at the Mandalay Bay Hotel and Casino onto a large crowd of concert goers at the Route 99 Harvest Country Festival. Country music, for country music enthusiasts who might very well be in support of that very Second Amendment right, that right that is celebrated in the great state of Nevada. Yet this concluded in much the same way that so many of these scenarios do, at the country music festival on the Las Vegas Strip, where more people died than in any other mass shooting in American history. The shooter then shot and killed himself, committing suicide. When the first responders got to the hotel room, they found an arsenal that had been amassed. Evidence captured by security cameras shows the shooter for 2 weeks bringing bags and packages of different things that he ultimately used to kill so many. Following this worst mass shooting in history, we learned the term bump stock, a device used to modify firearms, altering an otherwise legal firearm into a machine gun. As a result, the federal law was changed 2 months later. Bump stocks were banned by the United States Justice Department in December of 2018. a rule banning all devices that turn legal weapons into machine guns. Prohibited. So maybe the Second Amendment expectation that shall not be infringed, as we will examine, can very well be regulated. After all, we think back to the 19th century. Were you permitted to bring the firearm into the saloon? When I was in Tucson, Arizona, there was a sign prominently displayed outside of the Waffle House instructing patrons to leave their firearms in their cars. So the right to keep and bear arms, pursuant to that 1789 ratification of the Constitution from the father of the Constitution, our fourth president of the United States, James Madison, it's a qualified right, as is evidenced by the bump stock. We have the right to keep and bear arms so long as they're not machine guns. And if we don't like the modifications of a traditionally legally acquired weapon that might turn that weapon into a machine gun, then by altering, by modifying that handgun, that weapon of choice, into putting projectiles at a very high velocity, particularly into an area where people might be injured or killed, well, then we need to do something about that. We need to look to the law. And the final rule was changed ever reactively, with more bloodletting, more blurred vision as we look backwards at time to the precedent, the way that the court might very well scratch their head and attempt to reach some sort of a conclusion by interpreting the way that the legislature might craft those legislative solutions to redefine what a firearm might be. The final rule with the bump stock, pursuant to the Gun Control Act and the National Firearms Act, includes bump stock type devices. Devices that allow a semi-automatic firearm to shoot more than one shot with a single pull of a trigger by harnessing the recoil energy of the semi-automatic firearm to which it is affixed, so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter. And so we ask ourselves, how do we square that Second Amendment with the prospect of death? How about those life-altering physical injuries, including paraplegia or worse, as has been suffered by so many in these mass shootings? And we might welcome the transgenerational trauma for our children, our families, our communities, and lock them into a vicious cycle of trauma simply through the access to weapons and the perpetuation of criminally minded individuals who use those weapons to achieve the worst. So, does denied purchase equal a crime prevention measure or a Second Amendment violation? Can we reinterpret the Second Amendment? Our 46th president urges Congress to act, but to act short of amending the Constitution to reinterpret what it is that shall not infringed truly means in this era, this 21st century, this post-pandemic repopulation, where we are welcoming ourselves to an exaggerated interpretation of all of the tension that we have lived through for the past 230 years. So is this a qualified or an absolute right, this Second Amendment right that we will continue to explore that shall not be infringed? Is it to fight tyranny? Perhaps it's the tyranny of traffic being cut off, the road rage illustrated in the year 2021 in Santa Ana, California, with the death of a 6-year-old boy in his child protective seat on his way to preschool, where his mother gave testimony to indicate that she cut off and flipped off, well, the wrong young man sitting in the passenger seat, brandishing the handgun that he purchased lawfully, that law enforcement found at his place of employment, together with his social media, the bearded shooter, The bearded shooter who was on the run for over a week, like Bonnie and Clyde with his girlfriend, ultimately apprehended outside of the sushi restaurant in Southern California, where this individual bragged about his use of weapons, the power and the control that this young 24-year-old male can exhibit. And he did just that, not only with the shot that he fired at the car driven by the mother of the decedent, that child who is no longer with the living, who paid the ultimate price. In his expectation for a Second Amendment, he had no chance to make a choice. And so now the shooter, the 24-year-old, is in custody, charged with murder, with those sentence enhancements, the use of a firearm, firing into a vehicle, firing into an occupied vehicle. So what do we do? How do we fight tyranny, the tyranny of road rage? Well, some legislative bodies might suggest that the solution is to make sure that every car is sold with a holster and a weapon at the ready. For you might very well encounter road rage. How about the rage at the workplace, at the home? Forever a permanent solution to a temporary problem in the form of a firearm. Might that problem be interpreted in a particular way if we suffer from mental illness, substance abuse, are riddled with suicidal thoughts, perhaps homicidal thoughts? Why would we want to have absolute access to the firearm of choice should we be bent in a particular direction? It's Title 18 of the United States Code, Section 921, that defines what a firearm is. A firearm means any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. And we look to pistols and rifles for such projectiles to be shot at various velocities, various rates, various degrees of damage. By any measurement, to kill and or blow holes in things, an equalizer, peacekeeper, for defense, for sport, for survival. How about a financial investment? You can pass the return on your investment on to those generations that follow, so long as they stay out of the bullets trajectory. People buy and sell guns for many reasons. From the demands of a rugged remote frontier nation to the tensions at play in our post-pandemic repopulation, we must once and for all square our Second Amendment expectations with the law. Since 1789, over 230 years, from our fourth president to the 46th, guns have been contemplated, regulated, and relied upon. Urban legend will have us believe World War II era Japanese Admiral Yamamoto observed, "You cannot invade mainland United States." There would be a rifle behind every blade of grass. Well, whether or not Admiral Yamamoto said this is subject to speculation. However, it is our 16th president, from one of his earliest published speeches, where Abraham Lincoln reminds us in his address before the Young Men's Lyceum of Springfield, Illinois in 1838, "If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all time or die by suicide." We need look no further than Lincoln's legacy to remind us Presidents and people are susceptible to gun violence. Presidents Garfield, McKinley, and Kennedy, all shot and killed in office, would agree, as would those who survived assassination attempts by gunfire over the past 2 centuries, including Andrew Jackson, Teddy Roosevelt, Gerald Ford, and Ronald Reagan. Criminally minded people using guns is nothing new, certainly not in the office of the president nor the United States Secret Service. Our 46th president urges us to keep building on the gun violence and crime prevention legacy, and now calls on Congress to take action to end our epidemic of gun violence. It's with that Article 1 authority that Congress may enact and or revise federal law, as they did, well, the last time we were faced with high rates of gun violence in the 1980s and early 1990s, where so many legislative bodies agreed to enact tough on crime legislation, scratching their heads, concluding through precedent what it is that they might be able to do about it. Although the Rehnquist era case of the United States versus Lopez tested the constitutionality of the 1990 Gun-Free Zones Act, a law forbidding individuals from knowingly carrying a gun in a school zone, demonstrates limits to such authority, in that the possession of a gun in a local school zone is not an economic activity that might, through repetition elsewhere, have a substantial effect on interstate commerce, because it is that Article 1, Section 8 Commerce Clause that is relied upon in the authority of the Congress to do something about gun violence. The law is a criminal statute that has nothing to do with commerce or any sort of economic activity, according to the 5-4 decision in the Rehnquist court, where Justice Scalia, part of the majority, maintained that under Lopez, Congress may regulate even non-economic local activity if that regulation is a necessary part of a more general regulation of interstate commerce. They just concluded that perhaps the spirit of the legislation, though good, lacked authority, for there was no connection between the guns in the schools and the overall interstate commerce that might be regulated through the authority of Article 1, Section 8. So what's the solution? What's the solution to the problem? If we have diametrically opposed interpretations of a traditional right that may or may not be infringed, how do we increase awareness? How do we incentivize behavior? Well, we look around the country and we see cities and states that are changing the law so that we might be exercising prevention, control mechanisms, ultimately accountability, not only for the shooter, but for those individuals who perhaps contribute to the ability of that shooter to do their worst. Those individuals who might very well legally transfer title, selling the firearm. How about those individuals who illegally accommodate the acquisition of a firearm? What about the manufacturers of the firearm, of the ammunition? Those licensed gun dealers now have more responsibility than ever, for they might lose everything if they don't properly comport to the letter of the law. And we look to the Second Amendment traditionally. Do we have the freedom to keep the firearm, freedom to carry the firearm, freedom to use the firearm? After all, what is the firearm other than a relic that might hang over the fireplace, used by some ancestor and some former center of conflict, containing layers of dust, Or might we have someone who might impose a permanent solution upon a temporary problem? It is who can and cannot acquire, who should not possess, who may or may not be able to transfer ownership of such a firearm, and what can or cannot be acquired, possessed, or transferred pursuant to the Second Amendment, which shall not be infringed with these legislative solutions. Well, let's take a look at the Second Amendment. Since June 8th, 1789, authored by that fourth president of the United States, the father of the Constitution, the author of the Federalist Papers, James Madison, who wrote a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. America's fourth president, who made such a major contribution to the ratification of the Constitution by writing the Federalist Papers, along with Alexander Hamilton and John Jay, concluded that a well-regulated militia, an able-bodied group of civilians eligible by law for military service. What does a militia mean in the 21st century as we wake up following the January 6th attack on the Capitol building in Washington, D.C.? Might we travel to the state of Texas to find the Huey P. Newton Gun Club, named after the founder of the Black Panther Party? We regulate our militia to provide defense with our high-powered weapons. And we use the strength and the power of the Second Amendment to the Constitution to have the Huey P. Newton Gun Club and to tolerate, if not celebrate, their right to exist. And as we consider the Huey P. Newton Gun Club, with all of the self-defense minded interpretations of the use of the firearms by way of the Second Amendment, should apply to those historically disenfranchised groups that we may or may not be sympathetic to. How do we justify the Wolverine Watchmen from the great state of Michigan? It is said that modern militias date to the early 1990s as a response to perceived fears of tyrannical government. Michigan has always been a hotbed for militia activity. Militiagan. Since the early 1990s, we might remember the Murrah building in Oklahoma City. There are a number of things that might indicate that the militia movement that might have been something that had grown out of favor, at least in the 9/11 era, is reemerging in the post-pandemic era of the 21st century, where the Wolverine Watchmen have been charged with conspiracy to kidnap the governor of the sovereign state of Michigan, put her on trial. The militias in Michigan have always been the kind to which other state militias look up to, according to accounts within the militia movement, not the least of which would be evidenced with the existence of the Oath Keepers in Texas. Perhaps the 3%ers who are present in the United States and Canada, both identified as militia movements, right-wing militia movements. And so we step back, we scratch our head, we dust off the Second Amendment, and we try to determine what it was that James Madison was getting at with a well-regulated militia, these able-bodied citizens that would be subjected to military service to defend the community. Theoretically, it might sound okay, unless, of course, you come across some individuals who might have an antithetical interpretation of reality. Maybe those individuals are associated with the Huey P. Newton Gun Club or the Wolverine Watchmen or the Oath Keepers or the 3%ers. Multiple members of these militia groups including the three percenters, have been identified as primary participants in the January 6th attack, riot, incursion, where we are still attempting to figure out truly what happened, where there was an individual who was killed by gunfire. And we ask ourselves about gun control. Who is it that should be able to own or possess such a gun, to purchase, perhaps a straw purchase, by any means necessary through gift, or the majority of the guns, as is often the case, found at those crime scenes, taken off the streets by law enforcement. These weapons, more often than not, depending upon where you look, are the proceeds of crime themselves, are stolen firearms, firearms that have been acquired unlawfully outside of the bounds of the law. And so, if a stolen firearm is used, maybe we can't hold the criminal actor, particularly if that criminal actor is no longer with the living, criminally or civilly accountable. Where do we look? Well, we look to the source of the firearm, the manufacturer, the party or parties that might be specific to the trafficking of that particular weapon, the modification, the supplementation, perhaps the instruction or the assembly of that weapon. And we look to those groups who cling to the Second Amendment interpretation of what a militia might mean and whether or not we have that right, along with the right to keep and bear arms, which shall not be infringed. Does that mean that we can't check the background of those individuals who are attempting to lawfully acquire a weapon? And after they have that weapon, what if they do something, say something, write something on social media that might indicate that they are intent, that they have impetus, the motivation to use that weapon in the worst way possible? The recent shooting in San Jose at the Valley Transit Authority, the workplace shooting where the disgruntled worker who had exhibited such red flags time and again, both outside of the bounds of the United States and while attempting to regain entry to the United States, stopped, questioned, reported on by coworkers. The file is only made public after he does himself in, after he does so many of his coworkers in. Red flag laws. The problem gun violence brings now welcomes conflicting approaches from different sovereigns, diametrically opposed prescriptions depending upon the laws of the city, state, or the federal government, consistent or inconsistent with the political will and their legislative, executive, and judicial authority of those jurisdictions, diverse solutions, both contested and adopted. Let's look at the most populous states. I'd like to compare and contrast, if you will, those two populous states, California and Texas. Both the place where mass shootings have occurred, both recently reeling from mass shootings, from gun violence. Both legislative bodies, the Senate, the House, the executive in the form of the sitting governors, have voiced different approaches to the problem posed by gun violence. In California in 2021, the California Senate Appropriations Committee passed Senate Bill 264, Senate Bill 358, and Senate Bill 715, objectively to decrease gun violence and promote the general welfare. These bills before the state Senate further restrict state employees, minors, and the general public who may otherwise sell, possess, or purchase firearm and ammunition, and increase the state prosecutor and the power of the state prosecutor to investigate, prosecute, and assess criminal violations. In response to the United States District Court Roger Benitez in the Southern District Court of California, who in Miller versus Bonta, formerly Miller versus Becerra, the name of the Attorney General for the great state of California, recently overturned the Assault Weapons Control Act of California's legislative solution, been enforced for nearly 3 decades. California's 3-decade ban on assault weapons has been overturned by the federal judge, arguing that it violates the Second Amendment's right to bear arms. We can go back to that last era, that era of Lopez, where we are scratching our heads collectively in an attempt to quell the gun violence of the moment. And in the 1980s and in the early 1990s, as we took these approaches, California prohibited the sale of assault weapons in 1989 with the Assault Weapons Control Act. It established the assault weapon as a new classification of firearm, though arguably any firearm might be used in an assaultive manner. The Assault Weapons Control Act also prohibited anyone from buying such weapons without a special permit. But those who already owned a firearm that was deemed an assault weapon, they were able to keep their weapons. Similarly, at the time, President Clinton signed the Public Safety and Recreational Firearms Protection Act, commonly called the Federal Assault Weapons Ban, which was a part of the Violent Crime Control and Law Enforcement Act of 1994. It changed the federal criminal code to prohibit the manufacture, transfer, or possession of a semi-automatic assault weapon. However, it specified which semi-automatic assault weapons were included. It banned specific firearms and certain features on guns, but because there are so many modifications available, it stopped short of banning all semi-automatic weapons outright. Many such firearms continued to be legally acquired and used. It also banned the transfer or possession of large capacity ammunition devices that carried more than 10 bullets. In response to Judge Benitez's ruling in Miller versus Bonta, California Governor Gavin Newsom and California Attorney General Ron Bonta announced the decision is fundamentally flawed, and we will be appealing it. There is no sound basis in law, fact, or common sense for equating assault rifles, as Judge Benitez did. The AK-47 specifically was compared to a Swiss Army knife. Attorney General Bonta wants to remind us that there is no sound basis in law, fact, or common sense for equating assault rifles with Swiss Army knives, especially on Gun Violence Awareness Day and after the recent shootings in our own California communities. Our Attorney General in the great state of California suggests that we need to take action to end gun violence now, and pledges that we will fight this ruling and continue to advocate for and defend common sense gun laws dedicated to saving lives. Miller versus Bonta is pending before the Ninth Circuit Court of Appeals and may very well find its way to the Supreme Court of the United States. But we must consider what it is that the governor from the great state of California and the Attorney General from California are suggesting. We might also explore those legislative solutions that are being agreed upon, enacted by cities throughout California to record every purchase of a firearm, to prescribe the duty to anyone who acquires or possesses a firearm to maintain liability insurance. So if anyone is injured with that firearm, well, it's the indemnification by that third party that we can call upon through the ongoing payment of that liability insurance. not unlike an automobile. This is the trend: to record the acquisition, to make sure that more than the shooter might very well be held accountable to those standards of behavior. And we have to square the notion with the Second Amendment and the idea that that firearm that might outlive the owner, that might become something other than a paperweight, or that relic that acquires dust that hangs over the fireplace, whether or not it poses a threat of injury to anyone within the proximity of that firearm. How might we approach this from the great state of Texas? In 2021, Texas Governor Greg Abbott signed into law 7 bills that expand gun rights in the state, primarily constitutional carry and prohibitions in federal gun legislation in the state. Governor Abbott said politicians from the federal level to the local level have threatened to take guns from law-abiding citizens, but we will not let that happen in Texas. We interpret the problem differently in Texas. The problem is not that guns are the cause of the injury, but that we have a tyrannical government that wants to take the guns that might very well be perceived to be the true problem. As it is Governor Abbott who reminds us that Texas will always be the leader in defending the Second Amendment, which is why we built a barrier around gun rights. And he justifies the 7 laws that he has signed by ensuring that they will protect the rights of law-abiding citizens and ensure that Texans will remain living in the bastion of freedom. These laws, briefly, Senate Bill 19 prohibits any government entity from contracting with any business that discriminates against firearm and ammunition businesses or organizations. Senate Bill 20 allows guests to store firearms in their hotel rooms. Senate Bill 550 removes the shoulder or belt holster requirements, allowing Texans to carry firearms in whatever kind of holster they choose. House Bill 957 repeals criminal offense of possessing, manufacturing, transporting, or repairing a firearm silencer. It also ensures that any firearm suppressor manufactured in Texas and that remains in Texas will not be subject to federal law or federal regulation. House Bill 1500 prevents any government entity from prohibiting the sale or transportation of firearms or ammunition during a declared disaster or emergency. House Bill 1927 authorizes constitutional carry in Texas, meaning law-abiding citizens can carry handguns without a license. Finally, House Bill 2622 makes Texas a Second Amendment sanctuary state by protecting Texans from new federal gun control regulations. 2 diametrically opposed interpretations of the problem. 2 prescriptions for a solution. One ultimately to question whether or not one should be in possession of the firearm. The other, making it a birthright. Depending upon where you are, in what state, in what jurisdiction, you might approach the needs of your particular matter in a different way. How do we analyze and assess guns, death, and freedom? As we again remember that definition of a firearm by meaning any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Might we be talking about a gun? Might we be changing the definition for what a gun might be? What about ghost guns? Those components, those parts of a gun or a weapon that might be assembled to produce an explosive projectile. And what does assault rifle mean, really? If it is the assault that we are concerned about, might every weapon be considered an assault weapon? As we consider the approaches of the states, diametrically opposed as they may be, those most populous states of California and Texas, we look to the highest court in the land for guidance, maybe to make sense of the tension that currently exists. We can look back within the past decade to 2008 and the District of Columbia versus Heller, where we determine whether or not there's an individual right that might be exhibited, might be rested upon, might be realized pursuant to that Second Amendment, which either is or is not inherently regulatable. It's Heller that makes the determination in the 5-4 opinion in favor of those Second Amendment guarantees that the right to keep and bear arms is an individual right. To maintain the ownership is an individual right that's not connected to militias. And in this 5-4 decision that favors the Second Amendment, those guarantees that an individual right to possess firearms independent of service in a state militia and to use firearms for traditionally lawful purposes, including self-defense within the home. Might the 5 out of the 4 justices put their fingers in their ears and say, la, 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 as they conclude that a firearm might be used for something other than self-defense, at least as it pertains to the law impacted from the District of Columbia, that federal jurisdiction. In the Heller case, it is those individuals who are empowered to acquire, to possess those firearms to protect the home in a lawful manner. We can look to the second case that is most significant in this line of cases that we must consider to determine how it is that we might once and for all conclude the Second Amendment and whether or not it is deserving of further regulation. We have the case of McDonald versus Chicago. Illinois is the land of Lincoln. In McDonald versus Chicago, the states are bound by the 14th Amendment and cannot ban the handguns that was at issue in this case in the 5-4 decision, which held that an individual's right to keep and bear arms is incorporated and applicable to the states through the 14th Amendment due process clause. Justice Alito further observed, it is clear that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. And the 14th Amendment makes the Second Amendment right to keep and bear arms fully applicable to the states. So it looks like we currently, with our 46th president, might have a reform-minded prevention advocate who is calling upon Congress, who might be bent in the same direction that they were when they crafted the Gun-Free Schools Act of 1990 or the assault weapons ban of 1994. We look to that highest court in the land who now has agreed to hear the case of New York State Rifle and Pistol Association versus Corlett, currently pending before the Supreme Court, to ultimately define the right to carry guns in public. Because this case seeks a bright line rule in regard to public carry gun control laws, which defer to the state's compelling interest to protect the public by restricting possession of guns in public spaces. A lot of attention will be directed toward the court, as this case will be argued in the fall of this year with a decision expected sometime next year. So where do we go from here as we move forward from here to the next tragedy, to the next time we have a meritorious conversation about things outside of the courtroom? What takeaways might we have for practitioners as we consider accountability that is shifting away from the shooter, the indemnification, the liability insurance, the manufacturers, those suppliers, those recorded transactions that might be used as evidence to implicate more people to liability, to accountability, perhaps in setting the stage and delivering the instrumentality through which the worst will occur. Ammunition. Without ammunition, the firearm is simply a paperweight or a relic that collects dust over the fireplace. Depending upon where you are and depending upon the needs of those individuals that come to you for direction, guidance, depending upon the jurisdiction, we might be able to interpret that Second Amendment expectation in a particular way, whether or not it shall be untouched or whether or not it should be inherently regulated. And as we consider the liability and those deep pockets to make those plaintiffs whole again, those individuals who have been injured physically, traumatized, transgenerationally, deprived of their able bodied use through paraplegia or worse. The Brady Bill. The Gifford Center. Why is it that we look to those victims of gun crime to breathe sensibility into the way that we might interpret that Second Amendment? Why is it that the victims of gun crime have different interpretations of reality? Might we consider those interpretations as we consider the best way to move from this particular era, this episode in our American experience that is riddled with gunfire? Firearms continue to be the most common weapon used in homicides. Gun suicide deaths are disproportionately high in the West, but across the board, it is that suicide, perhaps predicted by Abraham Lincoln, that will be our undoing. So, how do we solve these temporary problems that we might encounter? Although California's gun violence rates appear to be lower than the national average, it's difficult to conclude how much of that is due to onerous firearm regulations. In spite of our Second Amendment expectations, there is incentive for regulation because guns continue to be injurious to people and property. Moreover, cities throughout our nation report increased gun-related crime and homicides since the pandemic hit last year. The gun laws that we examine are calculated to prevent and respond to gun crime. Obligatory background checks, red flag laws, sentence enhancements for the use of a firearm are legislative tools calculated to identify people who are likely to misuse firearms, restrict their acquisition, and deter future acts of violence. However, time and again, incidents and statistics remind us that criminally motivated individuals are less likely to follow such laws. Further, in spite of good faith efforts by legislatures throughout our nation, we continue to witness record gun sales and increased gun violence due to multiple factors, including mental health, substance abuse, domestic tensions, socioeconomic conditions, to name a few. Therefore, gun violence and gun-related homicides must be addressed through extrajudicial means with an ongoing commitment to cultural change. On behalf of the Center for Continuing Education, I'm Greg Woods.